Remember, we have our three elements of the tort of defamation. We have, is there a defamatory matter? We have publication, and that's where this video fits. And then we have identification of the plaintiff. So what is republishing? Basically, every time someone disseminates a defamatory item, it is published or republished. So the original writer of a book which contains defamatory material or defamatory imputations about someone is considered to have published it. When their publisher prints it, that is another publication, because the original publication is sending the manuscript to a third party, the publisher. The publisher prints it, that's a republication. It's displayed in a bookshop. The bookshop owner is republishing that item by displaying it for sale, etc., etc. However, you'll be thinking this is very unfair at this point, and we will look at a defence of innocent dissemination, which protects a lot of the people in the chain. However, there is a possibility still for liability for publishing a defamatory statement. And each separate publication, each time someone else forwards an item or republishes it or puts it in a new format or offers it for sale again, that creates a separate cause of action. In Wake and John Fairfax, they said that every act of publication will give rise to a separate cause of action in defamation. So every individual in the chain of dissemination, the journalist, the editor, the proprietor of the paper, the printer and a newsagent, all have created a new act of publication. And this is considered to be republishing that defamatory matter. Section 23 of our Defamation Act says that leave is required for further proceedings in relation to publication of the same defamatory matter. So what they're looking at there is the court has to give permission. You either have to sue everyone in one go for a single cause, for a single action, or the court has to give permission for you to sue somebody new. Leave is a process where a court must give leave or permission for someone to take a step. So in every case where there is a publication, you'll see that people generally try to pick their defendant carefully, and they'll try and pick a defendant who actually has money usually, just as a pragmatic thing. But then they may actually sue multiple defendants at the same time, the journalist, the newspaper, the publisher, etc. In addition to that, there's also Section 38, which talks about mitigation. Mitigation reduces the amount of damages. And if a plaintiff has already received damages for the publication of a defamatory matter, then they will receive considerably less for suing someone else for the same matter or something that has the same meaning or effect. So effectively, if they sue someone, succeed and recover damages, and then sue someone else who has republished something with the same effect, they will only get basically one set of compensation for the damage to their reputation. So it reduces the damage that has to be paid by the second person. Similarly, if a plaintiff has brought separate proceedings for damages against a number of people for a matter having the same meaning or effect, they can't double dip. They can't keep getting more and more damages. They can only be compensated for the damage that they have suffered and not double, triple damage. So in that situation, that will be taken into account for the amount of damages they get. And if the plaintiff has already received or agreed to compensation for a matter which has the same meaning or effect, so they sue a TV show, they settle, and then they decide to sue the individual journalist, the court can take into account that settlement where they've already been given or already agreed to get compensation. So it's generally the practice that people will try to sue all potential defendants in one go, or alternatively sue only those defendants who it appears could actually pay that damages. And remember, damages with an S, think of it like a $sign, damages is the remedy where you get money. So this only applies to the remedy where you get money, Section 38. So what are some examples of republishing? Here are some cases that have actually looked at republishing via the internet. And that is probably one of the most common sources of republishing today, though of course any production of a TV show and then later dissemination on a broadcast channel, or any writing of a book and printing, etc., of course also contain republication. The first one there is Dow Jones and Gutnick. The issue arose in that case because Dow Jones and Company, who are the publishers of the Wall Street Journal, ran a story about Gutnick, who was a South Australian, and it was actually a relatively defamatory item that they ran. That publication was initially published in the US, and many of you may have heard the US has much stronger defamation, much more limited defamation law than ours, and much stronger defences. So Gutnick may or may not have had any chance if he'd sued in the US. However, people had downloaded that article in Australia. And here, as you know, we have relatively strong plaintiff favouring defamation laws compared to the US. And so in our situation, Gutnick could sue and have a greater chance of winning. But Dow Jones tried to argue, no, this was written in the US, so therefore the jurisdiction it should be heard and the law that should be applied is the US. And our court said, no, we have rules around choice of law, and the choice of law that they were looking at for the tort included looking at where was the material published and where did the harm occur. And in this situation, when they said that any time someone downloaded material from the internet onto their computer, that was a publication. And that occurred when and where the content of the publication was available in a comprehensible form. So the downloading onto computers in South Australia meant the item was published in South Australia, which meant then that Gutnick could sue in South Australia, and he won. That has been modified by Section 11 of our 2005 defamation legislation. And if you look at the Section 11, it talks about choice of law for defamation proceedings. Choice of law is a legal term that says which jurisdiction's law do you apply if there are multiple jurisdictions involved in a case. So in a defamation situation, that might be where something was originally published overseas and then republished here, or where the defendant lives here and is harmed here, but it was published perhaps elsewhere. So Section 11 talks about choice of law for defamation proceedings, mostly focusing on the Australian jurisdiction. It makes it clear that if there has been a publication in an Australian state and that the harm and other elements of the defamation have occurred predominantly in one Australian jurisdiction, then you apply the law of that jurisdiction. If, however, there are multiple jurisdictions involved, so something is published on the internet and people download it in every state of Australia, which one do you pick? And the court tells you, the Section 11 tells you to look at where the predominant harm has occurred to the plaintiff. So where does the plaintiff live, or where is the plaintiff in business, or if the plaintiff is a corporate entity, which jurisdiction then has it got its primary place of business in. So have a look at that section and be aware that really in any area of law, if you've got competing jurisdictions involved, there will always be a choice of law rule. That's actually an area of law called conflict of laws or private international law, but Section 11 of the Defamation Act makes it easy for defamation proceedings. So what about these last few cases? They all involve Google. And they're really quite interesting because they're about what happens when you plug in your Google search terms and then you're offered a series of links with perhaps short descriptors underneath, or in the case of the Tricoola case that's listed there, an image search with a range of images. Is Google responsible for what pops up based on their automated web crawlers and based on the content of other people's websites? And the answer is, it depends. If you look at the case of Duffy, what had occurred there was that Dr. Duffy was an academic. She was somewhat looking at psychics and their claims. And she published some stuff around psychics. Part of it involved her going on to particular websites, and then she went to the Rip-Off Report and published critiques of psychics. They were then very unhappy about her, and they published comments on her reviews, basically claiming she was a stalker, claiming that she was targeting particular psychics, etc., when in fact what she'd done was access their services and then do a review. She found that after a while, when people Googled her name, what was coming up were these little snippets from the Rip-Off Report. So you'd get your link to the Rip-Off Report, and then people saying Duffy is a stalker of psychics, etc. She sued Google for that. Why? Google has a lot of money, and it's often when you're picking your defendant, you're going to think very carefully about who could actually pay you damages and how much. So yes, it's a little cynical to pick Google rather than the individual reviewers, but they were mostly anonymous and Google was identifiable. There were some issues around Rip-Off Report as well, and she also sued them, but she sued Google. And with the Google case, the court at first instance, so the trial court, with the Judge Blue presiding, said that after Google had been notified of Dr. Duffy's preference and concern about these statements about her, and it allowed these statements to continue to appear in its search results, it had some control of that. They said that Google had control of the search results in that they controlled the programming of the original programs that found the search results, and certainly once they were notified of the adverse search results, they then definitely knew of the content of the search results. That was, and Google lost. Google were found to have defamed her by allowing these search results to come up, saying that she was a stalker, saying she was targeting psychics unfairly, etc. They, of course, appealed because that was not something that they wanted to stand. Google, as well as being a high-income potential defendant, is also someone who has a lot at stake in protecting the ability to, protecting its own ability to resist defamation cases. So it appealed, and that went to the full court of the Supreme Court of South Australia. So you can see there SASFC, just here with the citation. That means South Australian Supreme Court, and it's indicating the full court. It's a 2017 case, and it's case number 130 of 2017. So in that case, a court of 3 judges heard the appeal, and they decided the same thing, that Judge Blue had got it right, that Google controlled the mechanism for its search results, and of course, once it was aware that these search results were being returned with defamatory matters and they allowed it to continue, then that is clearly defamatory, but they did control the mechanism for how these search results first came up, and that showed defamatory material against Dr. Duffy. In addition, there became a predictive search result where her name would be put in, but it would immediately come up with a predictive result indicating that she stalked psychics. That was also seen to be under the control of Google because it does have mechanisms to intervene in predictive search results, and it was aware of them and it didn't stop it. So Google was found to be defaming Dr. Duffy.